been drawn by the company cannot give you a right saying that the company has acted or the company has accepted with. No, unless where the proposal form is to be accepted. And it also made an observation of this, my friends. In every contract of insurance, it so happened that the contract gets concluded only when the party to whom the offer is being made and it is accepted with unconditionally, and when it is communicated to that of the acceptance. And said that today it is so happening by the courts that in several cases it so happened, the Supreme Court makes an observation, in several cases it is happening that we are making the company liable to bear the entire loss, but without any statutory compulsion on their part. Look, it observes me, without making any statutory compulsion. See, in order to have a valid contract, even because Contract Act is applicable to that of the insurance company also, because it is also in contract, it said that there should be an offer and acceptance, and after having acceptance there should be a communication made, and until and unless an acceptance is being made, it is not an offer. The acceptance would not result into a completion of contract. So taking this as a scenario, somewhere we are lacking. That is when you look at the principles of equity, even where no premium is being paid, even where if the check is being given and if that is going to be dishonored, what good you are making with the consideration? We are not following the principles of the contract. That's what the Supreme Court says. But still, we are coming heavily on that of the insurance, ignoring of these facts, but we still go with granting the order of payment. So what the court really showed its concern was that we have to observe the principles of contract, and in this case the court said that the company was still in the act of preparation of policy, as such reason the contract was not in existence, and as the contract was not in existence, you cannot have a right to claim. The same way in LIC versus Bindu Bowls and others, the same Supreme Court said that is when the policy is being issued later, that is if I have paid it on the prior date, and if the policy has come into existence, and if the contract was to be concluded on a different date, it has been effected, and if it is going to be concluded on a different date, and if it is been intimated to you on a different date, then we shall see that, or it shall be understood that this policy has come into existence and the premium is being paid. So these things becomes more important, my friends, in respect as how the premium is going to be made. But in a distinct manner, if I am to go with, premium is said to have been made. That is, mere payment of your money will not say the contract has come into existence, or mere paying of consideration after the date cannot also put you saying that the contract has not come into existence. It is the day of which the company has accepted your proposal. That is, offer and acceptance should be there, and when there is an offer and when there is an acceptance, that is in case of yours insurance, when the proposal is been accepted by you, by the company, then that day becomes the contract into existence, and thereby the company is said to have agreed the premium. That's why we say, usually in cases of premium, the general practice is that the first premium has to be paid by the party, but sometimes we see that it can also be waived by the person. But in today's scenario, if you look, it says no, you have to pay the premium with the money, and it has to be satisfied with the money. And how do you make your premium? See, when it comes to the types of premium that you are going to pay, one is net premium, we also call it as pure premium. Pure premium, we also call this as, or it is also called as gross premium. These are the two kinds of premium we can come across with. And what is the differences between this? That's why I said there is an actuarial science behind this. There is a mathematics behind this. Now, what is this net premium? See, when I say net premium is based, or it is calculated on the past experience. See, it is based on the past experience, mortality, and the assured rate of interest, plus assured assured rate of interest. Assured rate of interest. So putting in all together, that is, what is the past experience? When I say past experience, my friends, during the past, that is the settlement of what the claims that the company has made in, and what is the number of settlements it has been made, to what number of persons the settlement has been made. They may be falling from 10 to 20, 20 to 40, 40 to 55, 55 to 75. What is the number? What is the number of payments, policies that the company has paid with? On the basis of this, the past experience of what the company have, on the basis of that, the calculation takes place. Plus, what is the mortality rate? When I say mortality rate, it is something, what is the expected life of a person? What is the expected living of a person? What is the expected loss in case of property if damage is going to be caused? So these things, see, when I say accidents, all accidents does not result into total loss. Sometimes you can have majority of the times you can have a repair of those good parts which is being caused with. Whether if my vehicle is going to travel only in Bangalore city and not more than that, in Bangalore city if I am to travel, I cannot go more than 50 to 60 kilometers speed. So my speed cuts down the risk of accidents also. Maybe I am not saying we don't have an accident, but fatal accidents can be reduced there. So what is that? So mortality is also be looked in. And what is the assured rate of interest? When I say assured rate of interest, my friends, we shall see this. What is the company is going to get the interest? How it is going to get the interest? Suppose, say, if I am to take to you with the LIC policy, that is one way in where determination goes with. Let me speak to you when I come back to the determination. But on the basis of the assured rate of interest, what the company is going to get, on this basis, my friends, on all this basis, the net premium is going to be calculated. When it comes to the gross premium, it is not just these things. One more is added to this, that is loading charges. Loading charges. A loading charge, that is, again I am repeating, if it is a net or pure premium if I am going to pay, it is past experience, mortality and assured rate of interest is calculated. But when it comes to gross premium is an inclusive of this along with loading charges. And what is this loading charges? Loading charges is that, my friends, which varies from types of insurances which you take with. Types of insurances policy which you take with. In a simple word to say with, it is the expenses what a company would incur in getting out this policy. See, a part of this, there might be an age factor, or there could be a whether I am taking a participating or non-participating one, or whether I am going to desiring of going for the bonus of on my policy or what. All these factors would come in, but most of the thing we say that it is the charges what the company is going to incur. Maybe the commission which is going to pay, maybe for the purpose of this office administration work should be there, or maybe the stationaries are going to be involved in. For that purpose, we say it is loading charges. So, loading charges is something which is an inclusive of this, and plus a loading charges makes it as a gross premium. And this gross premium is again further divided into two ways. One is single premium, that is we call it as lump sum premium, and level premium. So these are the two kinds of methods. Level premium is where, of course, methods of computation of premium, but I'll be saying you with this. But when you go level premium is nothing but it is a payment of premium has been made in equal number of installments. That is what we call it as level premium. And what are the factors influencing for the cost of this insurance? Three factors are there. There are three factors which would generally have an influence on this payment of premium. The first factor is mortality. The second one is loading expenses. The third one is the interest, as I then said to you. These are the factors that which we see it in the net premium, and also we see it in the gross premium. What is the mortality? It is which is calculated rate is that is, it is calculated on the rate of mortality. That is, what is the number? Suppose say I take 100 persons, we have the age group of 25 to 50 years, then what is the rate of death among these out of this 100? That is how the mortality is going to be made. What is the mortality? See, because of this pandemic time, we say that what is the mortality rate of deaths that is looking. In Karnataka, they say that the mortality rate is very low. That is, the death rate of those persons who are infected with this pandemic is very low comparing to that of other states. That's what the mortality speaks with. What is the mortality rate? This is the first consideration. That is how on the basis of this cost, they are going to decide the premium. Second comes is the loading expenses. Loading expenses is the cost of getting the new policy, expenses of collecting and renewing of premium, administrative costs, management expenses, commissions to that of the agent what is being paid, medical examination what the company could take. All this becomes the loading expenses. This is one, a part of past experience I'm speaking. And what is the interest? See friends, interest is what a company could receive from that of the money what is being collected by you. Suppose say, if the entire amount what has been collected by the company, that is entire premium amount what has been collected by the company may come to the company to an extent of 5,000 crores. What is that? The company would keep it in box? No. What the company can do is that the company would invest. It invest in the government, or it could go in investment in banks or so on and so forth. Say for example LIC. When you pay a money for LIC, every year, maybe at the March end of the year, the company proudly advertises saying that this is the number of crores the company has targeted with. Saying that 5 lakhs of crore rupees has been collected by the company and it is an achievement for the year 2020, the company says. Now, what is this 5 lakhs of crore rupees that the company do? Maybe the company may invest in government, the company may invest in mutual funds, the company may deposit in bank, the company may also give it through insurances like HFL, housing financial companies, LIC housing finance companies, so and forth. So whatever the interest that is being collected from out of this would be deducted from the total number of premium, total amount of premium. So the company would have some expected amount of rupees which it could receive upon with. It would be having a very constructive calculation, my friends. Constructive calculation it makes with. And looks out what actually the interest that the company would get out. And that amount what the company could get in the form of an interest would be deducted from out of your premium. So the interest would be deducted. See, past experience it looks, mortality it looks, then it looks out what is the interest that is going to be made, and on the basis of that the company is going to charge you the premium. So determination of premium can be made, that is one, whether you are willing to take the property, especially in life insurance I'm speaking, whether we are willing to take the policy on death or whether it is on the maturity or on both, or whether your determination is going to be made on, that is in the very beginning itself, that is how you would go, you are going to pay at the very beginning, or you are going to pay at the end, or with this, it is with the number of duration of years. This is one another criteria. Or it will also be determined on the number of persons who has been insured. It will also be determined on the year of policy, that is number of years of policy you have taken. Or it shall also be calculated on the probability of the number of claims that has come in, the value of the claims per year that has taken with, number of years that the company is, interest is involved in, and to find out the value. Suppose say I have taken for 5 years, what shall be the value of that? Estimated value and claims of the year. Future value, estimation of the computation of the future value as a claims per year. That is, it values, it calculates out with it estimates with. And it also looks in computing the net single premium, or whether you are paying in a divided number of policies. So all this will be taken into consideration, my friends, in having calculation the premium. And how is this calculation been made? How is it looked at? How is this computation is looked at? My friends, we have 3 calculations, 3 assessments. One is assessment plan. Assessment plan. This is the one. The second one is natural plan, or we can say is, of course, natural plan and level plan. This two, or more or less it has become redundant now. These two have become redundant. We only go by the level plan. I was saying I'll be speaking to you a minute later. Assessment plan is the plan which was being followed in olden times. And what is this? Suppose, say, assessment plan. If there are 100 people, and if any one of this, suppose the 100 workers are employed in a company and they have agreed to have an insurance among themselves, that is, each have contributed. Now, in an assessment plan, what they do is that if one of the dies, 99 would pay for this one. Suppose out of this 99, maybe 30 might have died. 30 might have died, then 69 is remaining now, even after the loss. Now, if out of this 69, if one dies, 68 pays the money. Now look at this. This became futile for, it was followed for several years in olden times, but this became futile for this, the reason that, see, when it comes to the last person there, if 99 are also dead, and if one is there, he had paid for all those 99 and he gets nothing after his death. So, this resulted in the lapse and ineffectiveness of assessment plan. Second comes is the natural plan. Natural plan has those plans which came out in the middle of the ages, that is, in the Middle Ages period. And it was a practices of Middle Ages. And here in this, my friends, the greatest demerit, because of the demerit, this came out, of course, that is there. That is, what is that you are required to do here? See, in this kind of a plan, that is a natural plan, see, if you are living for 20 to 30 years, then one payment. Then 40 to 50 years, one payment. 50 to 60 years, one payment. Look at this. See, when I am living for this period of time, maybe I might require to pay 1000 rupees of premium. When it comes to here, I might require to pay 1200 of premium. And when I am living to between 50 to 60 years, I am required to pay 1500 premium. So, as of the day I grow older, I am required to pay more premium, and this was also not so effective. And because people never used to come, because it's a competitive world. People never used to come. The assured would never used to come say that maybe if I live longer, I may take. Now, what they have come out with a plan, a beautiful, colorful plan they have come out and says that, forget, if you are taking from 20 to 60 years, if your policy maybe for 30 years or so, 40 years or so, then we'll level out the plan. You are paying 1000 rupees, na? Yeah, 1000. So we'll level out and make it as 1150 for every year. For entire 40 years. I'll pay with this. So, that is, you leveled out the policy and this became more popular, and this is how we have calculated. So, here the mortality is taken into, on the basis of this the calculation would be made and the premium are going to be made. Especially in cases of life insurance, my friends, age is considered, sex of the person is considered, because sex is more equally important. Especially that too, if a lady were to be a woman and a lady were to be under pregnancy, or if she has married, then the risk of what the company is taking more comparing to the male people. That is the reason why it looks in. They look into the sex of the person to whom the insurance has been given, the profession of what they are carrying with, the habits of which they are having. Of course, we'll never ignore with sometimes the agent who comes in would say nothing, but still habits becomes an important, health condition of a person, the family history of a person. All this becomes an important to fix out the premium that you are going to be payable on it. But having fixed out a premium, when the payment is to be made, or when the payment of premium is being made, and to whom the payment of premium is being made, or by whom it can be paid with. See, the common thing in the insurance is that we have also understood this. The policy will not get attached unless the premium is being paid on my policy. That's what I said even in my previous part of our discussion. The policy will not get attached unless I pay upon with this, or unless where the company waives upon the payment of premium. In fact, section 52 of the Marine Insurance Act says that unless where the payment of premium is being made, there is no duty on the part of an insurer to issue a policy. So, this in a way we can say that it has made a condition precedent, the practices has been let down, it has made a condition precedent saying this, that you have to make a premium, you have to pay a premium in order to have a policy to you. However, the payment is not very necessarily. And what this restriction calls for you is only for the payment of first premium and not for the second premium. Suppose, say, if I have entered into a contract with you on 29th 6 2020, if I have entered into a contract with you on 29 6 2020, then this payment of premium is said to have been made by me today. And if this were to be my first premium, and if the proposal is being accepted on this day, payment is being made on this day, I shall say that yes, this is the premium what has been paid and the policy has come into existence. However, when it comes to the second day of my premium, that is subsequent payment of premium, I may have a grace period of time. Maybe that is, I'm required to pay it on 28th 6 2021. I'm required to pay. But however, the companies may give a grace period of 30 days. So I can go even for 28th 7 2020. So even when my payment is being made within this day, it is said that the payment is said to have been made and the company becomes liable. But when it comes to the first payment of premium, it is necessary that this payment of premium should be made on the first premium shall be made on the day of which the policy has come into existence. So in this, my friends, might be say, the Act lays down saying that the payment of premium other than by way of money, by way of agreement if you are entering into, otherwise then it is being waived with, then we shall say that yes, the payment of premium is being made by the company. Suppose say if I have made my payment of check, I like to give you this. Suppose say if I have made a payment of premium by way of check, and the check would have been made, the same example I am taking here, the check would have been drawn, or the check would have been stated, or it has been drawn on the date of 25 6 2020. But this check was honored by the company on 29 6 2020 and the proposal is being made. Now when is the payment being made for this? It is not on 29. Though the check was drawn on 29 6 2020, but whatever the date which the check carries with, that name should be taken, or that day should be taken as the payment of money by the person as to that of the insurance. This comes when it comes to the grace period of time. Suppose say I have 1 month of grace. The company might have said this. Suppose say I have drawn it on 25th and the company might have honored on 29th. Can you say it is a lapse of policy? The check is honored. See, the check is not honored, then this rule is applicable. But when the check gets honored, if the clearance is been satisfied, it is always understood that it is made on 25th itself. So whenever when it comes to the drawing of check, my friends, the check is drawn or on a particular date, and if it is honored, then the check is said to have been made on that day where the date is being endorsed on that of the check. This is one situation. In a simple way, I'll go across with how is this payment being understood when it is being made through a broker. Because normally we see that an agent runs to us. Maybe every year at the time of renewal he comes to us and he may collect the money and go files it before the company. The question could be asked for your part B area. Where an insured is required to have a transaction with that of a broker and not directly with the insurer, then if you are paying a money to that of your broker, my friends, then we shall say that the payment is said to have been made only when the broker files it to the company and a receipt is being drawn. That is the reason why we say whenever when the payment is being made, a kind of acknowledgement is required to be taken by you. And that acknowledgement is a piece of evidence which shows that the payment is being made by you. Suppose I give it to the broker. In the same case, I give it to the broker. The broker pays it on 30th of this June. Now, Can you say that? You might have paid on 15th itself because of some act of the broker, or because of his negligence, or because of his ill health, he could not go before the company and he could not pay this. Now, in that case, does it mean to say that you have paid the money? Says no. Until and unless where the money is being filed with that of the broker, then till that day it says that the payment is not said to have been made. And at the same time, it makes that if a payment is being made on grace, that is a periodical basis. Usually, my friends, it so happens by every company. In fact, when you are entering into a contract with the company itself, there will be a number of grace period which is being given to you in a level premium policies, we say. In case of a monthly payment, 15 days of grace would be given. In cases of quarterly premium, 15 days of grace would be given. Even in case of half-yearly payment of premium, 15 days would be given. And in case of yearly premiums, my friends, 30 days would be given. There is no such bar, it should be only 15 days, because no law speaks upon with this number of days of grace. It could be 5 days also or 10 days also extended, anything, but generally we say it is 15 days. So with this number of days, you can have a days of grace, and when insurance is being paid within this number of days of grace, then it is said that the insurance is still in effect. Once when the lapse is being taken place, that is when you have failed to pay the money on the lapse of the payment of which you are required, then we shall say there is a lapse of your premium. And what actions that could be made? Once if you fail to pay the premium, even within the day of which it is being made, normally the company, what they do is that there is no such rule, that is notice will be given to you prior in hand of 15 days or 30 days before. So that is saying that there is a policy renewal is been pending before you in respect of the policy what you are holding with. But there is no such compulsion, there is no such rule that the company is compulsorily required to give you a notice. No such restriction is there on the part of a company. The option is left over to the company, but generally the company follows this and they give you a notice before 1 month in hand, so as to make your payment of money as to the policy what you are holding with. So when you fail to pay the policy get lapsed. The company can take an action against you for non-payment of money, or even the company can go for forfeiture. Forfeiture I will speak to you in the fag end of this topic's discussion. So all these actions can be given. But what is if there is a deficiency in the installment payment is being premium paid by you? Deficiency is being made. See, when the premium is being paid and accepted, okay. That is, this is suppose say 1000 rupees is the premium and I have paid and the premium is accepted by the company, fine, okay, it is acceptable. So we both are knowing that is 1000 rupees, for that 1000 rupees I have paid, accepted by the company, premium is done. But for this 1000 rupees, if I pay 900 rupees, what would be the effect? This is a technical area where we have to understand deficiency in the payment of premium amount. Now, if this is being accepted by the company, even after the payment of 900 rupees, if the same is accepted by the company and the company issues a acknowledgement, a receipt of saying that as the premium is being satisfied, then premium is said to have been made by you. Suppose say, if the premium has paid by you to an extent of 990, but for want of 10 rupees, if the premium is said to be pending by the company, and if it is not accepted, then we shall understand that the premium has not been paid by you but to the company. So what we should understand here is that once when I say premium should be incomplete. If there is a deficiency in the premium, then the company can refuse. But once when it is accepted with this deficiency, it is understood that as the payment of premium has been satisfied by you. Only action is that the company can come forward for you for recovery of that 10 rupees of money or 100 rupees of money, otherwise it is not possible. Let me take to you a very interesting case here, which can be asked for your problem area. See, in this case, Baboram, B-A-B-O-O-R-A-M, Baboram Jain versus LIC of India. A very beautiful case, interesting case also. See, in this case, it so happened, the deceased was asked to pay an additional 10 rupees of extra premium on that of the insurance which he had taken with. For the reason that, and of course, Babul Ram, that is the deceased was already, that is he had already died, but his claimant, that is person who has a claim on this, comes before the nominee of them, comes to claim before the, on behalf of this party, that is deceased person. In fact, the deceased has to pay 10 rupees of additional premium on that of the money what he has taken with. And it said this, and it said that is during the course of his medical examination, the doctor comes to know that is during the existence of his policy, because maybe after some span of time of years, the examination has to be made. So the doctors came to know that this person has lost one tooth. Because that he has lost one tooth, the company said that, see that you have lost, the same premium cannot be continued on your part, because now there is a deficiency, little more deficiency, risk has become little higher, so you have to pay 10 rupees of more on that of the premium. Taking this, even on the medical report, and taking this, what the person do? The person goes to the company, pays the money with the same amount of what he was paying before. The company also issues him a policy saying that as the policy has been renewed. After this, it dies. And when it dies, the claimant under this policy comes before the court. Of course, they make a claim first before the company refuses, and they come before the court. And when it comes before the court, the company takes a defense saying that there was a suppression of the fact of this, and that there was a loss of tooth. On medical examination, we came to know that there was a loss of tooth, and we asked him to pay 10 rupees of an additional amount on that of the premium which we had undertaken with, and he has not paid, so the company is not liable. There the court going through this matter, it said that when the contract of life insurance, when the contract or when the proposal is been accepted by the company on the payment of premium, the deficiency or the defect of payment of 10 rupees would not vitiate the contract. See, you should not have accepted, because I was then also saying you this. See, what shall be the premium? The adequacy of the premium is left to the parties to decide with. And when you have accepted the premium that is being paid by you, it is understood that yes, you have given up, you have waived the right in respect of that 10 rupees. So, mere non-payment of 10 rupees will not vitiate the policy of, and on the death of the insured, they are bound to confer, or they are bound to satisfy the obligation which they have undertaken with. So, in this way, my friends, we shall see that when it comes to the when it comes to that of the payment of premium, we shall see that the company was bound to make. So, what we see is that it is something where you can say the principles of estoppel is applied here. The principle, when you have accepted, it is understood that yes, you have bound, that you are satisfied with this. So this is one area. And how is this premium be revoked? Revoked. When is that premium can be revoked, or when is this premium can be returned? That is one of the important questions which you will be asking in the examination. That is, what is premium and when it can be revoked or when it could be returned. Generally to say on this area, my friends, premium once paid shall not be returned or cannot be revoked unless it satisfies. So in a way I can say this clause as an exception. Again I repeat. See, once when the company accepts your premium, generally the company has no power to revoke the premium, or it cannot cancel the premium what you have been paid, unless where it is of these criteria. One, where there is a fraud on the part of the insurer or the insured. Suppose say I have hid my age and I have stated that my age is only 20 years, whereas it has against to my age is 35 years. I have committed a fraud. So in such cases, I am not entitled to. So I have a right of revocation. The second one is where the policy itself has become void. Where the policy has become void, then also we cannot say. Or where no risk is incurred by the insurer. Sorry, where no risk is incurred by the insurer. Risk cannot be made out. Risk is not satisfied. Suppose say I have taken a policy for my voyage, or I have taken a policy of some transportation here. Now because of this pandemic, the transportation is totally banned. Now what is the effect? Where is the risk? I cannot take the policy, I cannot transport the goods of mine, and transportation has become standstill. Where is the question of risk here? The risk comes only when I transport my goods. If the transportation itself is not there, then where does the question of insurance comes in? So in these cases, my friends, we can say that the return of policy can be made. That is, the company can revoke that of the policy. Apart of this also, my friends, we shall see that there is a part premium can also be refunded. When in cases like where, that is, I again repeat, the part premium can be refunded by way of revocation. One, it is when your insurance is a over insurance, maybe by miscalculation. Suppose say it is 1000 is the premium and I have paid 120 rupees. So 120 is more than what I have paid. So this can be, that is called as over insurance, and that could be paid. Or in another way I can say that, so if my goods is worth of 50,000 rupees, but I have made it for 60,000 rupees and the premium is collected for 60,000. Now that is over insurance, we'll say. So once when there is an over insurance, the same can be returned. This is one. Or where there is an effective terms, when there is an express term to that of an effective concern, that is to that of the effect. A way I can say you is that where there is an expressly a terms are entered into, in such situation the policy, that is the amount should be returned back. That is, in cases of no eventualities, partial of the amount would be returned back to you. In such cases, my friends, we shall also see that this could be returned back. And the third situation is that where a company goes into liquidation. See, having paid you the money, the company wants to go further with the insurance. But if the company itself goes into liquidation, it goes into its winding up, then you cannot proceed with the matter, or you cannot enter into the insurance, so the payment can be made. Or where there is a partial failure of paying the consideration. I have agreed to pay 1000, I have paid only 2,200 rupees, 800 rupees is not being paid, then again the company can return back the premium. So in these circumstances, my friends, the revocation or return of premium can be made by the company to you. Except of these cases, in all other cases, once when the payment is being made by you, payment is being satisfied with you, you cannot revoke the premium or you cannot refund the premium. So this is one another criteria. The next issue comes as like lapse of revival policy. Can there be a lapse? Suppose say, when does this lapse takes place? Lapse of revival policy. Lapse and revival of policy. Sorry for that. Lapse and revival of policy. See, lapse is that day where I have failed to pay the payment which it stands to be due to the company, or even after the grace period of time, if I have not made a payment on it, then on the last day of which I am required to make, even after the grace period, if I have not paid, then that becomes a lapse of policy. And once when there is a lapse of policy, that is, both the parties shall feel that it is necessary, they can go for the continuation of this policy. So in that case, the person can approach the company for reviving of policy, or even where we see that the company may, by giving a due notice, can call upon for the revival of policy. So if both the parties accepts to the continuation of the policy, then we shall say that the revival takes place with the policy. That is giving rebirth to that of the policy, getting a life to the policy for its existence. So usually we see this, my friends, under the scheme, the company, especially in cases of life insurance I'm speaking, because it is a welfare scheme which you cannot just go by the hard terms of rules which is imposed in. So in cases of life insurance policies, the company quite time and oftenly under the scheme it gives out. Those who have lapsed their policy for the period of so and so is given with an opportunity to revive their policy by paying such amount of penalty. So if you are interested in, or if you want to have your revival of policy, then you can come before and you can enter into the contract by paying such amount of penalty, and you can review the policy what you have entered into. Mind this, once when there is an offer being made by the insurer himself, and the insured has accepted and has satisfied that all those dues. Suppose say I was due to pay of 50,000 for the whole lot of 5 years, and that due is being satisfied along with the penalty. Then my friends, we shall say that the company cannot refuse on such calling upon the parties. Once when it is accepted, it is final, the policy comes into existence. Because all these things, question comes as when I go for honoring of this in case of eventuality, in cases of peril. It says that. So if the company tomorrow says that, so maybe say on the revival, on the acceptance, tomorrow if I dies, the company cannot say, look for all these 5 years he has not paid and tomorrow I am not going to pay. Because once when it is accepted, it is final and the revival of policy has taken place. And there is also one more restriction here is that, my friends, by reviving of policy, the company cannot enter into a fresh terms of contract. It cannot impose a fresh condition upon you. It is nothing but you are giving a life to that of the policy which has been lapsed, and the life of that policy again comes into existence. So once when it comes into existence, the conditions on which the policy is being taken continues with that of the old contract. So you cannot have a fresh contract to that of the premium. So this is one another thing that we can make. Suppose in this revival, or if it is with respect to the payment, as again I am to speak with, then I spoke with the broker, that is a payment made to an agent, by an agent or a broker. Whether the same payment in cases of revival, or whether it is in cases of a payment to be made, can a payment be made by a stranger? A very interesting question here. Can a stranger pay an amount of premium on that of your policy? Can he be paid? Suppose a friend of you or a stranger of you, can he pay premium on behalf of you, which to keep the policy alive? Is it permissible? And if so, it is being paid by the stranger. Or if so, if it is being revived by the stranger, where a payment is being made by him on behalf of you, will that policy becomes effective? In that cases, my friends, we have to see what is the effect of the payment made by the third parties. So many cases it so happen like this, my friends. A stranger, a third person may come down and make a payment of policy just to keep the policy alive. So in that case, my friends, it says that when a payment is being made by a stranger to that of a policy, or a friend of you to that of the policy will not be effective. Even where a stranger makes, where there is a lapse of policy, a stranger makes, or a friend of you pays out the policy, either he will have no right over the policy, nor he can have any right of lien on the payment of what he has been made with the company. He will not have any right. Subject to that, my friends, where if a person has entered into a specific agreement with the third parties, that is a valid contract which he has entered into, or on the request made by this policy holder requesting upon the third person to pay the money on behalf of him in terms of contract, then the policy becomes effective. So if a third person makes a payment, then he has to establish that there was a valid contract between both of this. If that is not there, it is not so. But the same is not so in cases of husband and wife, father and son, or mother and children, or so on and so forth. That is, in these cases, you will not to have an agreement showing that they have entered into an agreement for the payment, because the very payment of this money leads down to the presumption that the father has gifted to the son, or mother has gifted to the son, or son has gifted to the mother, or so. But when it comes to the mortgagee, when mortgagee pays a premium, then you can add them to the amount of his charge, subject to that of the agreement what they have entered into. So this is in one way we can say that whether it is a payment of policy or revival of a policy, it is only subject to this, my friends. We shall see the payment of premium can be made. And when is this policy becomes void ab initio? After having entered into a contract, after having paid the premium also, when is this becomes a contract of void ab initio? See, the void contracts is that, my friends, even where the consideration is being paid and claimed upon, it shall not be returned to that of the person, because you might have paid, but if the contract has become void, the company is not liable to pay you back. And what circumstances, what are the reason for saying that the company that is the contract which you have entered has become void ab initio. That is from the very beginning. Void ab initio is from the very beginning. That is, parties are not had idem. I repeat this, when parties are not had idem. Parties are not had idem. What is this ad idem? Ad idem is meeting of minds, we see. The simple word is that meeting of minds. In a way, I can say in every contract there should be a free consent between the parties. Both the parties should accept together. Having accepted, if both the parties have accepted and if they are contracted to that of the contract, then the contract is effective. Suppose, say, if I know nothing about the contract, I know nothing what has taken bit, but I have just has to sign and I have signed it. There is no even implied consent, implied understanding on my part. Then where is the question of contract, enforceability of contract? Suppose, say, in a rage of sickness, and it is in a day where it is impossible for me to understand because of my sickness, I am unable to understand what is going on. If I am of that status and if I am has to enter into a contract, and if the contract is entered into, can you call it as an effective contract? Says no, because there is no meeting of minds, there is no ad idem. So in such cases, if the contracts are entered into by the parties, where the parties are not had idem, where there is no meeting of minds has taken place with, then we shall say this, my friends, the contract becomes void ab initio. Anytime you can take this plea, anytime you can take this plea, and you can say that no, the contract was not actually carried between the parties, there was no meeting of minds, there was no consensus between the parties, so hence the contract shall be treated to be as void ab initio. That is from the very beginning. A very notable case which is asked for your exams, that is in case of Beach versus Parallel Life. A very interesting case. BEACH, Beach versus Parallel Life, PEARL, Parallel Life, LIFE, Life. A very interesting case this is. The proposer wanted to enter into take a policy of life insurance, and she called the agent of that, and of course a person of that, and she goes along with him to the company also. Let us different issue. She takes a policy of life for her mother. The policy was effected, but while effecting the policy, the insurer agent feels that the policy was taken not to her mother, for the grandmother, and draws the same, maybe the name could also be the same, let us not get into. He believes that the policy was being taken by this lady for her grandmother and draws it also. The policy was being given, and the policy was honored and everything was being made, payment was being made accordingly, everything was being made. But after few days of time, when the mother dies, that is mother of this girl dies, she goes for an honor, saying that the policy was being made. That is, the policy was entered into and the life of the mother was taken, and the same should be honored with. See, when she goes for the claim, then the question comes is that for whom the policy had been taken. See, to her sense, the policy was for the agent, that is, when the agent comes, he feels that it is for the policy of the grandmother. And he feels that the policy has been effected to the grandmother and not to that of the mother. So, when it has been effected to the grandmother, how can the policy be paid to the mother? And when this came up before the court, it crept out and said it found out that it was that this conduct complied by the agent and by the insurer, that is, the proposal who has been made, was crept out by the fault of the earlier party. So, as it was crept out from the earlier party, there was a mutual mistake between the parties. This is one of the important essential requirement for a contract, that is, for free consent of the parties. So, it found out on the evidences, it was found out that it was by a mutual mistake between the parties, and held that showing this as a contention, it said that there was no ad idem between the parties, and the death of the mother would not entitle the party to claim the money, and accordingly it dismissed the matter. So what we understand here is this, my friends. When I take the policy should be an ad idem, that is, there should be a meeting of minds, that is, there should be a consensus between the parties to whom the insurance is being taken with. If it is not there, then it is not possible. The second one is, it is an ultra virus, the powers of the company itself. Ultra virus, the whereas the powers of company itself. Powers of company itself. See, what can a company enter into? To the extent of powers what is being given to her, the company. Suppose say for example LIC. When I am taking an LIC policy with the company, can this LIC company policy issue a motor vehicles policy for you? If it issues a motor vehicle policy, it is generally understood that it is outside the object of the company. Once when it is outside the object of the company, from the very beginning itself, the contract becomes void ab initio. That is, it becomes totally void. This is the second condition. The third situation is that where the terms of contract is unascertained. See, we say that when you read section 29 of the Contract Act, it says to enforce upon the contract, to have a valid contract, it should be certain and unconditional in nature. If the contract itself is not certain, like something I was giving an example in case of Adidas, you are not sure. Suppose if you have 5 cars in your name, and if you are not sure that for which car you are taking with, for which car the insurance has been made, then where is the certainty comes in? You cannot just say for any one of the car that I am having with. You cannot say that, because if that is the case, then law does not permit you for taking this. So in that case, it says that even in such cases where you are not certain with what insurance that you are taking, or if the terms are not certain between you, then my friends, the contract cannot be enforced with. So it says that when you enter into a contract, it should be certain, or at least it should be capable of making it certain. Otherwise, it is said to be void. This is the third situation. And the fourth and last situation where it could be void ab initio is where the object of the consideration itself is illegal. Where if it is not in terms of law. Section 23 speaks with. That's what Section 23 of Indian Contract Act. When any object of you entering into a contract itself is illegal, where if it is opposed to that of a public policy, then the same cannot be enforced with. So in all these cases, my friends, we shall see the entire contract becomes void ab initio. That is from the very beginning. The next comes is the forfeiture and non-payment of premium. Friends, I was saying you this, where if you fail to pay the premium within the due date, or where if you fail to pay the premium within the grace period of time, then the company has one major right. In fact, it has, as I was speaking to you, the remedies done. That is, one, it can call for you to pay on the policy, or it can call for you for paying the interest, or it can call for you for revival of policy if it has already been lapsed, or the another thing is for forfeiture of policies. Forfeiture of policy for the non-payment of premium. So, forfeiture is something, my friends, when the company takes in, it is the drastic step which the company would be taking against you. As I then said, especially in cases of life insurance policy is a welfare policy. It is the welfare of the people. And if you are going for a forfeiture, we shall say that the forfeiture should be made only after all those reasonableness are being exhausted by you. That's what it says. That is 3 months of notice should be given to you. Only after the 3 months of time you have no other option left out by you, then the company can go for a forfeiture of shares. But in other cases of insurances, it is not so required with. But anyway, my friends, that is on the non-payment of the policy, or on the non-lapse of the policy, or non-payment of the premium on the policy at the time of which it is required to be paid with, then the company shall have a power of forfeiture. I'll take to you an interesting case here. In LIC versus Mani Ram's case, 2005 Supreme Court. See here, the deceased was insured for his life in an insurance company, and he had also paid his first premium on the 21/8/1995. He has paid his first premium on 21/8/1995. But look at this. I'll be very sure. 21/8/1995. Now, on the payment of this, the payment was accepted, But one request was being made by this person stating that don't make it as 21/8/1995, make this as 28, that is he requested and said that make it as 28/4/1995. So he sought for the insurance to be opened on pre-date, and the policy was opened in the 8th month, but he sought for 4 months prior to and said that let the policy be opened on 28/4/1994. Accordingly, the company also accepted and it predatedly issued an insurance policy to him. But when it came down for the payment of next policy, the question was this: should I pay it on 20th/8/1996 or it is 27/4/1996? This was the question which has come up before. The person contended saying this: as the policy was opened on this date, I should be paying on this date only. But as the policy was requested and it was opened on this date, of course there was a death of this person before that. The question came up before the court was that whether the court can go for a forfeiture and whether the policy is in existence or not. There the court said that no, when a person having requested to have a policy for the back date of which he has paid the money, then the policy gets lapsed as soon as the lapse of this time of 1 month from the day of grace which it has been given. And there the court said that yes, there was a lapse of policy and the company has a power to go for a forfeiture of those shares, of those policies. So forfeiture is something where the company acts for the non-payment of your policy, that is within the due date of your time. If you have failed to pay the policy, if you have failed to pay the premium which is due against that, then it leads down to the forfeiture of policy. However, in cases of such forfeiture of policy, certain rules has to be followed by the company, or there are certain conditions which has to be observed by the company while going for the forfeiture. See, when we go for forfeiture, no forfeiture act can be made by the company before the day of grace is being expired. I was saying you, sometimes it would be stated in the contract itself, but it says that is before the day of grace what is being given to you. Merely payment of policy on the elapsed day cannot take unless the person exceeds the grace period what is being given to him. So this is the first rule you have to follow in, or first condition you have to observe in. The second one is that if at the time of issuing the policy itself, it is being made very clear that the number of days of grace is being given to you, and within this days of grace, if you have not paid the policy, then the clause of non-forfeiture is also there on the policy. Suppose, say, while entering into a contract, I may be so that there could be a clause which could be imposed by me and the company that the company would not go into the forfeiture of your policy. If there is a clause entered, because all these are made in terms of contract, that is agreeing between the parties. If the policy says that no, I cannot enter into a contract, that is, there is a non-forfeiture clause imposed against the company, then the company cannot go for forfeiture. In such cases, what it happens is, see, if I have paid the policy, for 6 consecutive years and I have not paid later on, even after the grace period of time, I have not paid the policy, then in such cases, if there is a non-forfeiture clause, then if my policy is for 15 years I have effected, but I have paid only for 6 years, then the term of this policy should be reduced for 6 years of time. You cannot say that the company, that is, you have not paid the policy and there is a lapse of policy. Maybe you might be paying for 15 years, but the policy is going to be reduced for 6 years, and you shall be paying the interest amount what is being accumulated along with this amount till the extent of 15 years. So in that way also we shall see that the policy, the company should look upon when it goes for revival of policy. The third condition what it looks is that is when sometimes the insurer may agree to have a surrender of this policy. Instead of going for forfeiture, suppose, say, I have paid 3 years of premium and the remaining I am unable to pay. So in that cases, if you are unable to pay and if there is a surrender clause which has already been inserted in, then the company can call you for surrender of those policies which you are holding with. So when there is a surrender of that policy, it is the duty on the part of a company to pay that amount, whatever the amount he is entitled for this 3 years, along with its bonus if he is entitled. So the company cannot go for forfeiture of policies. This is the third criteria which it has to follow. And the fourth one is that even after having lapsed the policy, the insured has a right to make an application for revival of policy or renewal of policy. And it is no compulsion that the company should accept it, but an opportunity can be also given by the company. They may give an opportunity, and such if the policy holder wish to continue his policy, then on the payment of penalty and satisfying the conditions what is being imposed. I don't mean to say a fresh condition can be imposed. Satisfying the conditions whatever that is imposed in respect of the payment of policy, then the company may allow such person to go with the policy. So subject to these restrictions, my friends, we shall see that the policy can be revived with or it could be forfeited with. So you have to follow these conditions when you go for forfeiture of policy. Even in fact, the Insurance Act of 1938 has also made certain asterisks for revival of policy. So this is for forfeiture of policy, not revival, for forfeiture of policy. In fact, section 50 clause 1 says this, that is, no policy can be forfeited unless until where 3 months of notice is being given to the person for the forfeiture of shares. And within that 3 months, if he wants to get in to revive the policy, he should be permitted to do so. This is one condition. The second condition is under section 113 of the same act. This is also equally applied to all other cases, because the first one is section 50 clause 1 is only applied to life insurances. But under section 113 it says that it shall also be applied to the other cases where if the company goes for forfeiture, then at least 3 months of notice has to be given, and only after that the company can go for the policies. And one more restriction what is being made here is that, suppose, see, the forfeiture act is something which is, as I said, it is very drastic. It is a drastic step which the company is going to take. So when it is taking a drastic step, the person may have to lose his money. Suppose, say, if I have paid 20,000 for 2 installments, each 10,000, and because of this forfeiture I have to lose all this 20,000 rupees. But by the provisions of this, that is Insurance Act 1938 made it saying that if a person has paid the premium consecutively for 3 years, whether it is quarterly, half yearly or yearly, if you have paid it for 3 years, as I then said, then the company is liable to pay the money back to that of the person to the extent of what he has been paid, along with the entitlement of that payment what he has been made. So subject to this, my friends, you can have a forfeiture of shares. In one case, let me speak to you with this, Tolamal versus Lakshmi Insurance Company Limited. See, here the policy holder has paid 3 premium and he has defaulted later on with the payment of the premium. And the policy was kept alive. There was no act of forfeiture was taken place, or the forfeiture was not being made. The company has just kept alive or the policy for the entire year. Thereafter, what this policy holder do is that this policy holder assigns his policy to some other person, where this, as in the assignment, that is on such assignment, the person pays 2 months of premium on the policy and gets renewed the policy. But after having made the 2 months of policy, the person on whom the insurance has taken was died. Now, having died, the assignee comes before the company for the claim. The court says, the insurance company says that no, it was not possible for a company because there was a lapse of policy and it is the assignee who has paid this money, so the company is not liable because there was no revival of the policy. The court, going through this matter, accepted the revival, that is, accepted the premium paid by the assignee on such lapse of premium without going to an act of forfeiture, keeping the policy alive, yes, made to say that you have agreed on the terms of this revival. And accepting 2 months of your policy would state to say that the payment has been made, and it said that because of the death of this person, whatever the assignee is entitled to that on that of the amount over the amount payable shall be payable as the company was required to pay in before. So in this way, my friends, we shall see forfeiture of the insurance policy for the non-payment can be exercised subject to these limitations.